see new laws coming down the pipe in the next 3 to 5 years that's targeting private equity, both at the state level and at the federal level. That's maybe going to regulate private equity's involvement, in which case, then that's going to curtail private equity. But, you have to be very careful when you do this, because you can't necessarily say arbitrarily, nobody can invest in healthcare. So they have to find the right balance. And I think what they're going to find is private equity can continue to do it, but they're going to have to meet certain requirements to do it so that it doesn't get out of control. But right now, it's like the wild, wild west. And it's not just the major firms. Like I said, there's those small little one guy, two guy. We used to sell cars a few months ago. We're jumping in. There are social media influencers that are entering into the space. All right. And overnight, they're bringing in money.
Beyond the Scalpel, where a surgeon's journey outside the operating room explores healthcare, wellness, and human performance through conversations with leaders shaping the future of medicine, mobility, and patient care. Welcome, Dr. Mamun Alrashid.
Welcome, Ari.
Okay, today's guest, Mr. Jose Vela Jr., has served this country in uniform for 4 decades as a United States Army Lieutenant Colonel. He has prosecuted some of the most complex healthcare fraud cases in the nation as a federal prosecutor and former Assistant United States Attorney. He now stands at the intersection of law and medicine as a leading healthcare trial lawyer with Clark Hill PLC, working on matters as healthcare fraud, regulatory compliance issues, healthcare business practices, and other many hot-button healthcare regulatory issues that are at the forefront of today's healthcare landscape. Mr. Jose Vela, welcome to Beyond the Scalp.
Thank you for having me today. Appreciate it very much.
Awesome. So, Jose, let's start with the early part of your journey, your professional journey. You served in the military. Tell us a little bit about that chapter of your life.
Yeah, so in college, I was in the Army ROTC program. I was a 3-year scholarship cadet, and I had selected engineer to become an engineer officer. I dual majored in college in civil engineering and in government. Some colleges, they call it political science. At Notre Dame, they call it government, and with a concentration in international relations. So I ended up getting 2 undergraduate degrees from Notre Dame. And then after I left college, I was commissioned as a second lieutenant. Actually, 1 year before I left college. The program is a 4-year program. As a dual major, you do 5 years to receive 2 bachelor degrees. So I commissioned, I became a second lieutenant in the Army back in 1986. I believe that's when it was. And then I completed my studies the following year. And after I graduated college, I went on active duty for about 4 months and received my what we call officer basic course. See, for every officer that joins the military, depending on what your branch is, mine is engineer, you would go to that particular school and receive additional military training in that particular specialty. And so I did that at Fort Belvoir, Virginia, outside of Washington, D.C. The school is not there any longer. The engineering school was moved to Fort Leonard Wood, Missouri, which is about 2 hours, hour and a half south of St. Louis, Missouri. So currently that's where the engineer school is located. For any officers that are now going through the Army would go to that base and receive their officer training. After I completed my training, I went on active reserve and I was a member of the 416th Engineer Command. And over the course of the next 28 or so years, I served in a variety of positions, each one sequentially of higher authority and responsibility. So I was a second lieutenant. I was a platoon leader. I was in charge of a platoon of approximately 60 to 80 soldiers. And these soldiers were responsible for operating heavy construction equipment. I was part of a combat heavy engineer battalion, and my responsibility was to train these soldiers to be able to operate a variety of different equipment. And the one thing that kind of sticks in my mind when I went and became a platoon leader, before the practice was to use people in the respective vehicles that they were accustomed to using all the time. So what I found was when we go to do our training, and when you're part of the active reserve, you would do 2 weeks a year of training, and you'd go to a base and you would practice your craft. So for us, that would be building roads, building structures, buildings, etc. Well, so I'm out there the first day, and I'm watching the troops practice. And I pulled aside one of the more senior sergeants. I asked him, well, after about 3 days, I said, well, look, I'm seeing 2 or 3 guys on the machines doing all the work. And I see the other soldiers sitting and kind of watching and observing. And so I asked him, why are we not training all of the soldiers? So, well, because this is the way we've always done it. We know how to operate the equipment, and we have this exercise to complete, and we can get it done. And I told them, well, but that's not the point of this, is it? I mean, the point of this is to train every member of the team so that every member of the team can perform when called to do it. So what I did is I modified their routine and I implemented a new training on the fly midstream. I said, we're going to train everybody in the platoon to operate every single piece of equipment in the platoon. And some would say, but you're not going to be able to get the road done or the thing we've been asked to do. This is an entirely training event. This is what this is, right? This is the purpose of this, is to train people to do the work. It's not to have the most experienced people do all of the work. You already know how to do it. You don't need the training. So I made it a point to do that. And we started rotating. So we put the most experienced operator with people who had no experience, and we'd have them work together on different pieces of equipment day in and day out. And they would rotate throughout the entire 2 weeks we did that. I mean, the young soldiers, when they saw this and they experienced it, they became highly motivated. They were very engaged, and they got a lot out of it because they became really good operators over time. We continued doing this even during our weekend drills when we had opportunities to use heavy equipment. The thing is that in the military, every member of the organization needs to, number one, know what the mission is. Number two, know how to perform the mission. And as engineers, and you have equipment operators, it's critical that everybody needs to know how to use the equipment. The reason, and it's a very practical reason for this, in a combat situation, engineers do get shot at, engineers are killed. And that's just a fact of life. And so if an operator is killed or wounded seriously and can no longer perform, the next person has to step up, right? It doesn't matter whether it's a man or a woman, because I had both. You have to be able to step up and get on the machine and continue operating, even if the last guy fell. And that's the concept. And I carried that forward. So when I became a company commander of a garrison support unit, we supported Fort Lewis, Washington. And that's a base that had at the time maybe 40, 50,000 soldiers. And so garrison support unit, they go in and they work in different areas of the base. Logistics, for example, personnel, operations, whatever it is. And you work among the active duty personnel, and you're there. And we rotated people in and out the entire, maybe 3-4 months we were assigned to assist there. And it's the same, it's the same concept. So for me, it's number one, make sure all my guys are properly educated, get their military education, get their military training, and make sure they have good quality experience. And the idea is not just to be able to do your mission. What I want for them is to get promoted, to move up in the ranks, get positions of higher authority. And then I also want them to be able to use these as valuable life skills so they can use that when they leave the military. And as reservists, we're dual career. So we have our civilian career and we have our military career. And so we learn a lot of valuable skills in the military. Time management, for example. And we learn how to manage people, how to manage logistics. We learn how to conduct meetings. We learn how to give briefs, how to prepare briefs. So all those are very valuable skills. Many of those times you get those skills in corporate America, either in the boardroom or in an MBA program, where you're getting this in the military. And so there's a lot of opportunity to learn, a lot of opportunity to grow, and then to become a very well-rounded individual when you leave the military. So there's a lot of positive aspects of the military. But at the same time, we can't forget that it's obviously a very risky profession because you can be called to go into combat. right? And so you want to make sure that your folks are not only physically prepared to go into combat, but to be mentally and emotionally prepared to do it as well. Not that anybody really can be 100% prepared, because until you've actually experienced it, you really don't know how your body and your mind will respond to the events that are happening around you. So I did that for, I'd say 28 years in the active reserve. And then I went into the retired reserve for about 10 years.
Let me talk a little bit while you're kind of getting give your
And my
voice a little
apologies.
voice a little rest. I was going to say that even from just listening to that, it tells me like, you didn't just accept the status quo. You were always kind of analyzing the situation, the systems around you, and using that analytical hat. You were always looking for opportunities to improve things for your comrades and how to innovate and provide a better system. And I mean, and that's quite a tell. I mean, even at that, in an institution where there's sort of a very hierarchical system. But I think to the other point, which I was going to mention, was that military service instills skills of discipline, mission focus, ability to function under pressure, which you can't always teach in a classroom. So you must have come away with all this tremendous experience. And do you think that that kind of helped you as you kind of moved into your legal career or in the courtroom, for example?
So, as I had mentioned, I think there are a lot of life applications here that you can translate into corporate America, into other professions. So, and the one thing I want to point out is the one thing when I was a company commander, as a platoon leader, I had about 60 soldiers under my command. As a company commander, I had approximately 450 to 500 soldiers under my command. And I had probably 10 different sections that I had to oversee, that then went to Fort Lewis and supported, 20 to 40,000 soldiers, not just the soldiers, but their families as well who lived on base. So we kind of worked hand in hand with the active duty personnel to assist in base operations. But yeah, everything I learned there, I in some aspect or another, I would use in my civilian career. So whether it was with the US EPA when I left college and was working as an engineer with them in Chicago, and then transferred into the legal career.
Awesome.
Yeah. So I was with the EPA for 5 years, and I was in my first year with them in Chicago. And I remember I was doing some work with the Office of Regional Counsel in some cases. And one of the lawyers told me, you should consider going to law school. I think you'd be a good fit for that. And you can always come back and work with us. So I applied, got into law school, and I transferred in the EPA system. I ended up going to Michigan for law in Ann Arbor, Michigan. And EPA has a motor vehicle emissions lab there. And I transferred there and continued working as an engineer, but part-time, because I was a full-time student working part-time at the EPA. And in addition to that, I was also an active member of the Army Reserve. So I was doing that as well. So basically, I was going to law school full-time. I was serving the military, and I was working as an engineer simultaneously. Awesome. Yeah. So it kept me pretty busy. And
Right.
the plan was to go back to Chicago and to work with the EPA. But when I graduated, there was a change in the administration. There was a new lawyer in charge who did not know me. And so that opportunity wasn't available any longer for me. They told me I could come back as an engineer, which really would have defeated the purpose of going to law school entirely, really. And so that really wasn't an option. So I ended up going to work for a state's attorney's office outside of Chicago for about 7 years. And while I was there, I tried probably 42, 45 cases to verdict. I think I maybe only lost one or two. And part of my docket was representing the county health department. And so working with them, I developed an interest in healthcare, in healthcare and in public health, if you will. And I remember one of my colleagues had told me, when you grow up, you need to find a niche that you can specialize in. And so I thought about it. I said, well, maybe health law might be my niche.
Right.
So thinking to myself, and then I got an opportunity to be an assistant U.S. attorney, and I came down to Texas, and part of my docket was healthcare, and and it took a few different lanes. So one lane was in bankruptcy. I would represent CMS and HHS in proofs of claim where they're trying to collect on overpayments that were owed to them by providers who were in bankruptcy. Was part of my healthcare docket. Another part of my docket involved Medicare appeals. So providers who have an overpayment determination where the government, through one of their contractors, says, you owe us money back. We paid you, but that was a mistake. We want our money back. By the way, we call it StatRat. It's a statistical sampling and a statistical analysis that allows the government to extrapolate from the sample to the entire universe of claims. So they might look at 30 claims and say, well, we found an error rate of 60%. All right, you say, well, 60% of the 30 claims is, maybe 15, 20,000. You think, oh, that's not bad. But when they extrapolate that to a universe of several 100,000 claims, it's now like a $5 to $10 million overpayment determination. So naturally, most providers are going to appeal that determination. And so they have to go through a 4-stage appeal process. When they exhaust the appeal process, they have the right to go to district court and ask a judge to decide, to review and say, did they get it right or did they get it wrong? I would represent CMS, HHS in federal court on those cases many, many times. In addition, there are times when there were what we call program integrity cases. So for example, you might have a home health agency and they forgot to inform Medicare that they changed offices. Well, so then Medicare sends out, as they will periodically, or the state will do it, an arrangement with the feds and the inspector to see if they're still open and operating. Because that's important, because if they're not, they will terminate their enrollment. So in this one case, the inspector went out and saw the place was closed and there was no lights on, there was no traffic, and he went 3 times. Well, of course, there was nobody there. They had moved, but they forgot to let the government know they had moved. What was the result of this? Disenrollment. What's the result of that? No more payments from Medicare. Well, these guys said, oh, well, it was an honest mistake. And they wanted to appeal it, but there was no appeal. What's done is done. And so they wanted to re-enroll, but they couldn't because at the time in Texas, there was a moratorium on additional home health agencies. So because they've already been disenrolled, they could not enroll again. They were boxed out. And so that happens. And when they sue, I would defend the government. I would represent the government in those cases. And then the last area has to do with fraud. Probably my biggest part of my healthcare docket. I probably looked at easily 300 to 600, maybe more different types of providers, from very small family-owned ambulance services to very large hospital systems. One of the cases that I handled was in Victoria, Texas. It was a county-owned hospital, and there were 3 cardiologists that brought a whistleblower case against the hospital under the False Claims Act. The claim was that they were paying kickbacks to emergency room doctors in return for referrals to their pain center, their chest pain center, I think is what they called it, where they would run a battery of tests, EKGs, cardiograms, you name it, blood tests, to determine whether or not a person was either having a heart attack or at risk, or maybe they had hardening of the arteries, a severe blockage, and then they would send them to get a stent in the cath lab. So they brought the case to the government, which is what would typically happen. Cases would come to me a few different ways. It could be a whistleblower case, like those 3 cardiologists. It could be organic. So OIG might bring a case to us where there is no whistleblower, but they've identified anomalies with certain provider that based on their own internal analysis. See, what happens, they would use their own algorithms and they would look at the claims universe of a particular provider and they would determine if they were an outlier. For example, maybe they were prescribing a particular drug 500 times more than the other cardiologists or their other doctors or their peers within a certain geographical area. So they're an outlier. So they deserve greater attention. So they start looking at their prescription history. What particular drugs are they prescribing? Who are the drug manufacturers? And they start investigating to determine whether or not the pharmaceutical company was paying the doctor in one form or the other to prescribe their medications or to increase prescriptions or to switch prescriptions, whatever the case might be. So in this case, with these cardiologists, this whistleblower case, I got involved. We investigated the claims, and normally relators, we call them whistleblowers, they have their own attorneys, private attorneys who bring the case for them. And the good thing is that if you have a good attorney, they can review the case up front and determine whether or not it's a good case to bring to the government. There are a lot of reasons why they could be a bad case and not worth their time or effort to bring a case to the government, because the government's going to decline it, which means they're not going to pursue it. But in this case, we looked at it and we were able to determine that the hospital was paying the emergency room doctors, not directly, indirectly. They had set up a system where, based on the volume of referrals that were being made to the chest pain center, they were being compensated 50% of the reimbursement amount that was being brought in through their payments from Medicare. They had claimed that they were being paid for doing certain services, but they had no documentation to support it. None. If you can't prove what you say you've been doing, then it never happened. So, for example, many times doctors are recruited to be medical directors. Okay. And so I had a case down in McAllen involving a home health agency, and they recruit doctors to be medical directors. The reason they recruit the doctors is they want the referrals for their patients. And so what happens is they offer things of value to the doctor. It could be cash. It could be a furnished apartment. It could be a new car. It could be tickets to a expensive concert or a nice trip to Paris, France. It could be a lot of things. It could be Rolex watches, anything of value. And those are violations of the anti-kickback statute, the federal anti-kickback statute, which basically says you can't pay for referrals. Are there exceptions? Yes. But there's no exception to where you specifically pay for a referral, right? So in this case, I remember very clearly one doctor in particular met with the owners of the home health agency for lunch. And the first thing he said to them is, how much are you going to pay me for my patients? And they looked at each other like, because they weren't expecting the doctor to be the one telling them, hey, what are you going to pay me? He said, well, let me make it easy for you. Here's what I need. At the time, I need $10,000. I need a furnished apartment, and I need a girlfriend. And so those things happen. And the thing is, what tips it off is they don't have one medical director. They have 6 medical directors. You don't need 6 medical directors. And each one's getting 10, 15,000 a month. Then the question is, well, what are they doing for you? Oh, well, there are medical directors. Yeah, but what are they doing? What have they done for you? Do you have any documentation? Do you have timesheets? Do you have logs? So when you don't have any of that, then you have no evidence of real work for real pay. What you have is pay for referrals. Okay. And so the same thing with the doctors, the emergency room doctors in the hospital. They weren't really doing anything for that additional bonus. Those weren't performance-based bonuses. Those weren't based on any evaluations. They were strictly based on how many patients they referred to the chest pain center, which then converted into Medicare dollars. And so that case in Victoria, that case we settled with the hospital for around $23 million. And now I'm going to fast forward it to one of my last cases involving 2 ophthalmologists who were here in Houston. One was the owner of the clinic, an ophthalmology clinic practice, and the other was the medical director of the practice. So in that case, we had the whistleblower was an optometrist who worked for them at the clinic. And during the course of his work, he would go out to visit patients who were homebound, could not come into the clinic to be examined. And part of the examination at home was an eye pressure test. Same one you would do in the office, but with a different device. If you go to the office, they use what they call a Goldman's tonometer, which I understand is the gold standard for testing for eye pressure to determine whether or not a patient is a glaucoma suspect or at greater risk of developing glaucoma. And so there's a portable device called a tono pen, which you can take to the field and click it, it's like literally milliseconds, and it will take a snapshot instant reading of your eye pressure from your eye. If it shows that there is a problem, then they can arrange to get the patient into the office for further evaluation to determine if, in fact, they are glaucoma suspect. Well, the eye pressure test is part of a comprehensive exam. It is not a standalone procedure, and it gets billed together as one visit. Okay. Well, what the optometrist discovered over time is it was being billed as a separate procedure by the medical director and by the clinic. They give them a super bill to fill out, and on the super bill it has all the procedure codes. Well, they had come up with a procedure code for using the tonal pen to measure eye pressure, and the optometrists were instructed to check that one off when they measured eye pressure. He thought there was something odd about that. He started investigating himself and doing some research and talking to some outside sources. What he discovered was the procedure code that they were using was for tonography, completely different procedure, antiquated from the 50s, using a Chiat's tonometer with a recording device. Really only taught in medical schools, maybe sometimes, more for research now. It's hardly ever used in the field by any practicing optometrist. You'd be hard pressed to find somebody that does it unless they're doing research. So they didn't have the Chiat's tonometer to do it. They did not receive the training to perform the tonography procedure. And there was no evidence that they ever did it in the clinic. So he brought it to the doctor's attention. They told him, you don't know what you're talking about because you're just an optometrist and we're ophthalmologists, so we know. So we've looked at your concern, but it's not a concern. We want you to continue doing it. He was very worried about it. So what he would stop marking that on the super bill. But then later he discovered that the staff were changing it under instructions of the medical director and the owner. They were to bill it in that procedure code for eye pressure test. In reality, it was a tonography procedure code. Well, we get into the case. I deposed both of the doctors. They had several different defenses they threw at it. One was that the billing company was responsible. I deposed the representative from the billing company. The only involvement they would have is to submit the claims as they were coded by the practice. They did not do any independent auditing or determination. They weren't in the clinic. They didn't know what the doctors were doing. They only processed the claims. And if they get rejected, they would send it back to the clinic for correction. So they weren't responsible. Another defense was, well, that's what they taught us in our residency program. Okay. I went to the American Academy of Ophthalmology in San Francisco. I talked to their folks there. I said, I understand you guys publish the ophthalmology residency program for the majority of the medical schools in the country. Yes, roger that. I said, okay, here's what I need. I need the materials for your residency program for the last, whatever, I don't know, 7, 8 years. When these guys would have, in theory, gone to residency. I got them. I reviewed them. And lo and behold, in the materials, they talked about the difference between tonography and what this other procedure is called tonometry. Okay. So in other words, they were incorrect. It was not taught in residency programs. They were wrong. Okay. Then they said, well, the tonal pen, it's designed to do the same thing as tonography. Okay. It does the same thing. It's internal to the system, except it just do it real quick. Okay. So I went to the US Patent Office in DC and I got a hold of the actual patent for the tonal pen and for the Chiat's tonometer. Reviewed the claims that are in there and determined that, the tonal pen cannot do any of that. I went to the manufacturer of the tonal pen and got their user manual where it clearly states what it can do and what it cannot do. And I also got a hold of one of the principal inventors of the tonal pen, who was an ophthalmologist in Beverly Hills. And I got him to prepare a report and an affidavit, clearly showing that this tonal pen could not, it was impossible for it to do what a Chiat's tonometer could do. So I defeated that as well. So then they said, well, it's our interpretation of the procedure code and we're ophthalmologists and we're entitled to interpret it. And by the way, we got this material, some training session by Alcon, who sells eye drops and yada yada yada. I said, okay. So I got a hold of Alcon and I asked them, and I said, no. Got their training material. I said, well, no such thing. We've never talked about that. We quite to the opposite. All right, so that wasn't true. I deposed them. They admitted we don't have a Shiatz tonometer. We don't perform tonography, but we interpret that procedure code as allowing us to use the tonopen and to bill for it. And then they again said, look, the optometrist doesn't know anything because he's just an optometrist. And he said, and you don't know anything because you're just a lawyer. So how could you possibly know what we know? That's fine. I let them talk, say whatever they got to say. Well, I went to court with we call a motion for summary judgment, which is basically you go to the court, you petition the court, and say, okay, look, there's no issues of fact remaining. And as a matter of law, we're entitled to win and to get a judgment. Now, there were about 14,000 claims over 6 years that they submitted using that tonography procedure code. The total amount was around $800,000 to $900,000, which in this day might not seem like a lot of money, but if we prevailed in the case, the government is entitled to, we call it treble damages, 3 times. So 800 becomes $2.4 million. And we can ask the court for civil penalties on top of that, anywhere from $10 to $12,000 per claim that's submitted. That's 13,000 claims with the potential sky's the limit, basically. But so I went to court. We filed a petition. Again, I had affidavits from a board certified ophthalmologist who had taught in various universities around the country, done extensive research, hands-on experience with the Shiatz, with both the tonopen, the Goldman tonometer, the Shiatz tonometer. So he well-versed. I had the Beverly Hills ophthalmologist, the inventor of the tonopen, and I had someone from the manufacturer, and I had certified copies of the patents. And I had the manuals from the manufacturer. And so I presented the case to the judge. I asked for the $2.4 million in treble damages.
Mm-hmm.
And I also asked for about $1.5 million, $2 million in penalties. It was a very reasonable amount based on case law to ask. And the thing is that many times you say, well, you go after the practice and then you try to collect from the practice. What you realize is that in many cases, those practices are not liquid. They're passed through. As the money comes in, the money leaves the practice. This was very true with these 2 gentlemen. The owner, as the money would hit the bank accounts, he would withdraw the money from the bank accounts. So as a practical matter, the practice didn't have any money to speak of to pay for a judgment. And honestly, the government was not interested in collecting Goldman tonometers and tonopens and trying to auction them off to try to pay for a judgment, or examination chairs, or eyeglasses, or contact lens. So the key is to go after the individual doctors in that case. But the lesson learned there for your viewers is that don't assume that the government is only going to go after a corporate entity. Right? A lot of times you say, well, I set up an LLC and I set up a corporation and that's going to take care of it and I'm protected. Not necessarily. Because if you're a passive owner and you own it, but you're not involved at all, maybe. But the government's still going to look at you. But in most cases, the doctor owners, they're practicing. They're in the clinic. They're seeing patients. They're doing decisions. They're part of the decision making. Their hands are in the pot. And so they are going to be looked at very carefully. So with these 2 doctors, I was able to determine from their own testimony and from others, they were directing optometrists and their staff. The optometrist first, you will code it this procedure code. That's very deliberate. And the procedure code is very clear. It's tonography. And then the second thing they told their staff, if they don't code it or they code it differently, you're to change it and to code it this. All very purposeful, very intentional. Because they were active participants, they were personally on the hook.
Yeah.
That you're not going to be held accountable because you have an LLC set up or you have a corporation set up. They can still go after you. And in fact, that is DOJ policy. It was when I was there, and it most certainly is today, is to go after corporate officers, CEOs, presidents, vice presidents, the chief operating officers, to CFOs, chief financial officers, as well as investors who either are referring physicians or potential referring sources. So it runs the gamut. And so that's a lesson learned. So the government, I learned a lot from doing the investigations. I worked with OIG, I worked with FBI, DEA. I work with, we call it MAFUCU, Medicaid Fraud Control Units. I worked across the aisle with my criminal counterparts. I'd say 80% of my cases started as a civil investigation, as a whistleblower case, and based on the work I did, became a criminal case. So 80% of the time, my cases had a parallel criminal investigation. In one of my cases, I call it a triple header because it was started out as a false claim whistleblower case. It then became a criminal investigation. And then the entity filed bankruptcy. So we had a bankruptcy, criminal investigation, and a civil investigation all happening simultaneously. And so that's, that there's a lot involved there and very complicated in trying to resolve all three of those matters. And they don't always work out exactly how you'd like it to, but there is resolution there. So I did that. I was with the U.S. Attorney's Office for 21 and a half years. And then I decided I wanted to go into private practice. I was already finished with my military career. So I think for me, it would have been very challenging to be in private practice and be an officer in the Army. I was a lieutenant colonel at the end. I was the director of plans for a 2-star general. We had probably under our command 50,000 soldiers. And I was working for the G3, which is a chief operating officer for the entire command. And so I was involved very heavily. I mean, it was like a full-time job. I would spend several weekends a month working with the military, a lot of nights working with the military outside of my regular job as an assistant U.S. attorney. In fact, there were times when I was on military exercises where I would have to switch gears and I would have to talk to, for example, a chief of a border patrol sector on a federal case that I was handling for the government. Or on the flip side, I would be doing my DOJ job and I would have to jump in on a meeting with the general officer and full bird colonels where there was a hot button issue involving the command or some unit within the command that needed my involvement. So, and that's
And Jose, how was that for you psychologically, kind of doing that transition? I mean, kind of two different worlds a little bit. I mean, one, you're wearing the uniform, protecting the country, and the other, you're, helping the country against healthcare fraud. But I mean, sort of the missions there, but sort of that psychologically, how did you cope with that?
compartmentalize it. I mean, again, when you think back to what I told you earlier about working when I was doing law school, I mean, I was going to law school, I was participating in the military, and I was working part time. So I was already kind of accustomed to doing different activities. In high school, I probably did, I don't know, 10 different activities. Wrote for the paper, I was on track, I sang in the choir, I tutored, um, I, I did taekwondo. I was president of junior achievement. I mean, I was just always accustomed to handling a variety of different activities and in leadership positions. So naturally, when I was called to do my military and to do my work as an attorney, I was an experienced attorney, and I was because I had already been a lawyer for several years, and I was an experienced military officer. So because of that, you are able to prioritize, you're able to manage your time well. You're able to compartmentalize. And I got to the point where I can literally, like a switch, turn it on, turn it off as needed to be able to accomplish both missions simultaneously. So that was all very good experience for me. And then, like I said, once I retired the military and I had already been with the government for a number of years, I decided I wanted to go into private practice. I wanted
Yeah, before
to,
we go into your private practice, I just want to hone in a little bit on your, I mean, illustrious time with the, as a federal prosecutor. Just tell us a little bit about, like, how are you judged as a federal prosecutor? Is it based on the number of cases you win? What are the metrics? I mean, and how do you, kind of, what's the environment? How do you choose cases?
yeah. So first off, being selected is a process to become an assistant U.S. attorney. I can't speak to today. I can only speak to when I was selected to become an assistant U.S. attorney. There are 94 offices around the country. By office, I mean jurisdictions. So, like for example, where I am, it's the Southern District of Texas. Our main office is in Houston, but we have branch offices. So, in some areas of the country, If it's large enough geographically, you'll have a main office and you'll have branch offices. But 94 jurisdictions, 94 different U.S. attorneys, presidentially appointed, confirmed by the U.S. Senate. Every year, the Department of Justice, we call it Main Justice in Washington, through the Attorney General or the Deputy Attorney General, they set the priorities as far as for hiring, for the priorities on enforcement, for both criminal and for civil. But being selected, it varies from office to office. But generally speaking, they like to have attorneys who have experience already. So in my case, I was an attorney for 6.5 years when I was offered the position as an assistant U.S. attorney. I had tried about 42, 45 cases to verdict. So I was skilled and I was experienced. I had recommendations from probably 6 state judges who knew me personally, saw my work in the courtroom, and were willing to recommend me to become an assistant U.S. attorney. So I went through the process. I got hired. And then as far as your evaluations, again, it's visited year in and year out. The Department of Justice has their own set of metrics based on different variables. And then you get quarterly reviews or semi-annual to see how you're progressing. And then ultimately at the end of the year, they say, okay, this is where you are. And for next year is what we'd like you to do. So it can vary from year to year, but yeah, it's performance based. And then as far as caseloads, it kind of depends. So when I was in a branch office, because I started in one of our branch offices, we were only 2 civil attorneys. I was one of 2, and I pretty much handled everything that came in the door. So they sent me to the National Advocacy Center, which is a DOJ school in Columbia, South Carolina, where they sent all their prosecutors to get trained. I went there probably 16 times. Which is a lot, but I went for different things. So for example, I went there to learn about the Federal Tort Claims Act. This is basically the law that allows people to sue the government for negligence if they've been harmed. So a simple example is a postal driver is out on his mail route and he's not being careful and he doesn't yield the right of way and he hits a civilian who's just simply driving and following the rules. It wasn't, if they were negligent, that person who was harmed, either they got hurt or their car was damaged, they can file an administrative claim with the U.S. Postal Service. And then if it doesn't get resolved, they can go to federal court and sue the government for negligence. So I would defend the Postal Service in those cases as an example. That could be the VA if it's a medical malpractice case as well, or any other agency. In addition, I had to learn about constitutional torts. So for example, you've got somebody who's at a checkpoint between the border of Mexico and Houston, and they get pulled over or they get checked. And let's say in one case, a dog bites them. And by dog, I mean a Border Patrol dog bites them. Well, they can sue the government for 2. It could be negligence, or it could be that they were detained wrongfully under the 4th Amendment as a constitutional violation. So I would represent the Border Patrol. Interestingly enough, in a case that I had just like that, the lawyer for the person who, in that case, the plaintiff was at a checkpoint. He saw a German Shepherd. He made the mistake to reach out of the window to try to pet the dog. The dog did not like that. So the dog grabbed his arm, didn't bite, no break of skin, but he grabbed it, which is what they're trained to do. Well, he sued the government over that. And they named the dog as a defendant. Okay. So the German Shepherd is a defendant in a federal lawsuit. So I got the dog off, thankfully, and the case proceeded against the government. But that's one of those kind of weird cases that you get. I had another case involving a confidential informant. And for your viewers, that's somebody might say, well, that's a snitch. Well, yeah, yes and no. Confidential informants are individuals who have agreed to work for the government, maybe the FBI, for example, law enforcement agency, and to go undercover to help them determine whether or not a crime is being committed or is in the process of being committed. Whereas otherwise, the government would have no way of knowing, or very little way of knowing, whether or not there is a crime actually being committed. So we had a gentleman who was a confidential informant for DEA. He provided information. He was compensated by the DEA for his assistance. He was not satisfied with the amount of compensation. So he sued the DEA, which required him to disclose his identity. To this day, do not understand why, if you're a confidential informant, which means nobody knows that you're working for DEA, why would you want the world now to know that you were working for DEA? Again, one of those strange cases, hard to believe. So I had to deal with all kinds of cases. And then they moved me to Houston, and I ended up doing financial litigation at first. So it's like commercial litigation. So if the government's owed money, we would go after people to collect the money. Okay. I did that for a few years. In fact, I ended up being in charge of that group for a while. So I was the managing attorney. And then I went back to civil. And then 80% of my docket was healthcare. And at the same time, I went back to school and I got a master's of law in health law from the University of Houston, which is a top in health law. It's like a top 5, top 6 program in the country. So I did that. I did that part time because I was working full time and drilling with the Army. So I couldn't do that full time. It took me a couple of years, but I got it done. So now I have my master's of law in health law, which helps me do my work.
Right.
And then I went into private practice because I was looking to work in the same area, but I wanted to be specifically just healthcare, right? Whereas with the government, I did healthcare, but I also did other matters for the government. For example, we talked about bankruptcy. Healthcare wasn't the only part of bankruptcy. I represented the IRS in bankruptcy court. I represented SBA. I represented the Department of Agriculture. Basically, any government entity that was owed money by a debtor in bankruptcy, I would represent them to try to assist in collecting money through the bankruptcy process.
Right.
So I did Chapter 11s, which are reorganizations, companies that are just reorganizing. Could be liquidation, they're completely folding. Could be a Chapter 7, which is also there, which is, I think, a liquidation. And then a Chapter 13, which is personal bankruptcy. And sometimes you might have a doctor who's filed for personal bankruptcy, and they may have overpayment determinations against them individually that I'd have to take care of in bankruptcy. So a wide swath of cases that I handle for the government. Yeah.
So that kind of obviously prepared you and helped you, with all that experience on the prosecutorial side to then kind of go on to the defense. And you've been doing some amazing work and you write regularly on sort of these hot button topic issues. So let's kind of dive into a few of those issues, which are, very pervasive in today's healthcare market and kind of the forefront of kind of conversations. Let's go into private equity in healthcare. I mean, it's kind of an issue that's dominating the healthcare. There's sort of private equity engagement at various levels. Just give us a lay of the land and how you're seeing private equity investment really shaping the healthcare industry right now.
So if you think back historically to the practice of medicine 50, 55, 60 years ago, where it was typically doctor would have a small practice. Maybe there'd be a couple doctors in the office. You have your patients. There'd be the local hospital nearby where you could send patients to the hospital. Hospitals were charity hospitals or religious-based hospitals. Technology was not very, was for pretty rudimentary. You had certain vaccinations available. Prescription medications, I wouldn't say they were non-existent, but close to non-existent. Well, if you felt ill, you go to the doctor's office, you would get a shot of penicillin. You might get a prescription for a bottle of cough syrup, and they might prescribe you to take aspirin over the counter. There was no private equity. I mean, health insurance was also in its infancy at the time.
Simpler days.
Yes, there wasn't a lot of money in it, but if you were a licensed doctor in the United States, depending on where you were located, obviously differences for being like in the city of New York, for example, versus being out in a rural community in Colorado, you could have a decent lifestyle, okay, compared to other professions and occupations. A nice, comfortable lifestyle, a good pace, not overly stressful. You would think, unless you're like an ER doctor, for example, that might be different, but generally speaking. But things started to happen. One, private insurance expanded because employers were trying to attract more skilled labor to manufacturing jobs. It was the heyday of the I would call the iron area up in Midwest. A lot of manufacturing still going on, coal mines in the east, petroleum and petrochemical in the south, and to some lesser degree in the west. All of that, these companies needed workers and they needed to attract them. And that also expanded into mid-level management as well. And one of the things they came up with is offering private insurance, which not even been heard of really for the most part, but that was a benefit. And then they added on retirement, and then they ended up adding up life insurance as well. So beyond just getting a paycheck, they started offering health insurance. So now health insurance starts to grow over the next 20, 30 years as more and more employers start offering employer-sponsored health plans. Simultaneously, Medicare begins to expand, Medicaid begins to expand over the next 30, 50 years. Well, good reason one, growth of the country, the population increased significantly, either organically or through my immigration. So now you have a larger population, larger pool of individuals who need healthcare services. And more recently, with an aging population, with people having a longer life expectancy, people are on Medicare longer. So more Medicare services are being rendered. So these programs are expanding and spending more money. All right. And then, of course, commercial insurance started expanding. And with it, more regulations, more policies are being implemented to manage the flow of claims, claim processing, reimbursements, denials, appeals. That creates a lot of administrative work that maybe doctors did not experience in the 60s. That created an opening for expanding administrative services in the clinic and in the hospitals, if you will. At
Right.
first, it was organic. You would hire someone to come in and be your insurance coordinator, handling the claims, handling the appeals, things along those lines. And then at some point in time, those who were offering those services, they started doing it as vendors. So in other words, doctors said, I don't need somebody full time. I maybe can't afford to have somebody full time doing that. I'll source it out. And so now you have this development and growth of third party billing companies that offer those services for these practices. At the same time, hospitals are starting to grow and having to expand because larger population, more patient volume. The problem, though, is that many hospitals were not well run financially, and they were running in the red instead of running in the black,
Mm.
causing some hospitals to fail. Like back in Chicago, there were multiple hospitals that were failing in the 80s and had to close their doors. So there was a desperate need for help on the business side to make these hospitals. And it wasn't initially concerned to be profitable. It's just to be able to remain open, to provide access to the community, to be able to provide services to the community. And so you start having business folks, non-medical personnel enter into the space, providing those services. Now, mind you, they bring with them their experience from corporate America, right? They're not healthcare practitioners and they're not there for altruistic reasons to give the greatest access to as many people as possible. Their focus and their mission was we have to make the hospital not only survive, but we have to make it thrive so that it can continue with its mission in the future, meeting the needs of the patients, if you will. Well, along the same lines, because now there's more money now entering from insurance and payers, you start seeing increase in research and development in pharmaceuticals and durable medical equipment, DMEs, in laboratory services, in medical diagnostic equipment like imaging equipment. And so that starts to expand. All very expensive propositions because you're talking about going from low tech to medium tech to high tech. They invest a lot of money, millions, right? Billions in some cases. And for pharmaceuticals, for every one drug that makes it and gets through the new drug application process and gets approved by FDA, there are probably dozens that fail. They don't make it. You never even hear about them. That's
Right.
money that is lost to the pharmaceutical. And they obviously want a return on investment. So as new drugs start being developed and get introduced into the marketplace, pharmaceutical companies are trying to find ways to get doctors to prescribe these medications. because the only way they can be profitable is if these drugs get prescribed and someone pays for them. So they hire staff, they hire sales reps, they start going out, they start, creating lists of doctors and their prescribing history to identify who does what, cardiologists, gastroenterologists, and they start bombarding them. Hey, here's some literature on this and that, and that starts to expand the use of drugs. Simultaneously, they now start doing direct to consumer marketing, right? Before, you would never see an ad in a magazine for any prescription drug or on television. Now, I don't think you can get through a program on TV without seeing 3 or 4 ads for prescription
Right.
medications.
Right.
I don't think you can read through a magazine without seeing 6 or 7 ads for prescription medications, right? So, and the reason for doing that is to get the consumer, the patient, to request that drug or to at least bring it up with their doctor. Hey, I read about this or I saw that. Would it be good for me? And so that increased the use of drugs in this country, prescription medications. It exploded. I mean, I think now it's about 10-15% of the 4 trillion plus money that is spent is on prescription medications. In fact, I think this country spends more money per capita on drugs than any country in the world. Any country in the world. This country spends the most. And some would argue with mixed results. I think some would say we don't, they're not 100% convinced that everyone's benefiting from these drugs. But again, so you see this expansion of the use of medications, you see expansion of lab testing, and you see expansion of imaging services over time. And so there's more utilization happening. Well, we went from maybe, I don't know, $50 million industry back in the early 60s, $4 trillion industry today, plus and growing. It's probably 20 to 22% of the gross national product in this country is medical spend. I mean, so this is a very attractive market for private equity and for serious investors. They see an opportunity. Okay. So they've gone beyond just where you've asked us to help you manage your operations so you don't fail, to we're going to help you be profitable, to, oh, wait a minute, we can make a lot of money doing this. We should be running the show. And so doctors initially were happy to have the help because, like I told you, administrative nightmare, handling all the different insurance carriers, because your patient population could be represented by 7 different insurance companies and Medicare and Medicaid on top of it. And so that could be an administrative nightmare for any physician, for any practice. And you
Right.
could have really good people in-house who help you, but you might get to a point where it's even too much for them. And so you have to look outside to get help. So initially you're very welcoming. Yeah, that's really good. You're still running the show. It's still your practice. You're still the one who's profiting if there's profit to be made. But now it starts to transition in the last 10 years. Private equity is not really interested in being, your worker bee anymore. They're not even interested in being your partner side by side. They want to be the show, but they need you as a physician because in this ecosystem of medicine, the most important part that without that part, none of it works
Yeah.
is the physician, because the physician has the power of the pen. You can write prescription medications, right? You can write prescriptions. That turns into dollars. You can write lab orders. That turns into dollars. You can write imaging orders. That turns into dollars. You can write for DME, for home health services, for hospice care. Fill in the blank. And in every one of these subsectors of healthcare, private equity is involved. And what is their purpose in life? To maximize profit for their shareholders. And not for all shareholders, for the majority, the ones that hold the big ticket amount of investment. Fund managers from Wall Street, who maybe have a 10% stake or 15% stake, they get the most attention. And these guys want to get paid handsomely at the end of the year with huge bonuses for delivering to the big shareholders a large return on investment. But what about the physicians? Well, the way they're setting these up, the way they're selling it to some physicians is, look, we're going to take care of all of these headaches for you. So you don't have to worry about that anymore. You can just focus on taking care of your patients and being a doctor. And you'll get paid for doing that and you'll be fine. Now, look, for some doctors, that's exactly what they want. Because let's say they're close to retirement and they don't want to deal with any of that. They're just happy to still practice medicine, still get paid a reasonable amount, and go home at the end of the day. And you know what? That works great for them. But then there are younger doctors who are in health systems or have a practice and they're in a group and they're doing good and they get approached by private equity. Hey, but we can make you even bigger and better and more profitable. And you're thinking, yeah, why not? Let's do it. And you sign up. And then before you know it, they're the ones telling you what services to provide, who to provide them to, how much we're going to charge for them, what we're going to accept, what hours, what days, what staff, what kind of staff, how much we're going to pay them, who's really running the show now. It ain't the doctor anymore. You might just be a glorified medical director in name only. Okay. And as I may have mentioned before, or maybe not in this podcast, the one thing that private equity has had to find a solution to is the corporate practice of medicine. And what that is that in about 26 states in the United States, there's state law that prevents, and when I say private equity, I'm talking about non-physician types, because there are doctors who are in private equity, and I'm not talking about them right now. I'm talking about people that come into the industry who are not doctors. They're not licensed professionals. They prohibit them from hiring doctors, from supervising doctors, from directing doctors in medical practice. That's considered practicing medicine without a license. That's the corporate practice of medicine. It's a prohibition against it. Some states allow it, many states do not. So in the states that don't, private equity has come up with the Management Service Organization, or MSO model, business model. Basically, it's, again, you think about your third-party billing company, but supersize it. They do credentialing, they handle insurance claims, they process their orders, they hire the staff, the clinical staff. They do all of the administrative work. Okay. So on paper, they're not hiring doctors. They contract with a doctor to be a medical director. But wink, wink, they only do that with a doctor who agrees with them behind closed doors. We're going to pay you to be the medical director, but we're basically going to be managing the clinic. We're basically going to be managing it, and we're going to use this as a profit center for the MSO for our investors. All right. Now, where it gets really problematic is when they start pushing their doctors to prescribe, to order more lab tests, okay, to prescribe more medications, and then they tell them where they want it sent to. So they might want you to send it to a mail order pharmacy that they also own or control, or they want you to send it to a DME that they also own and control. And then to get you to do it, they reward you on the back end. They say, well, we're going to give you an investment part in the MSO, 1% investment, and then we'll give you distributions. But then we come to find out that your distribution is 100% tied to how many referrals you make. It's not based on your percentage of ownership. Oh, and by the way, you don't have to pay anything for your ownership interest. So in other words, you didn't pay anything to invest in it. They just put you in as an investor. The government's going to say that is a kickback disguised as an investment in an MSO. That will get you in trouble as a doctor. So part of what I do is I work with doctors, I work with medical practices, health systems, and when they are approached by private equity or they're considering expanding or buying or acquiring or selling off, I look at my part of it is I look at the part to determine whether or not this could violate the anti-kickback statute or Stark law or some other violation of state regulatory law. I have other lawyers that work with me that are in healthcare who can evaluate from the corporate perspective whether it's a good deal or a bad deal financially as a separate set-alone type issue. So together, we can look at the whole thing holistically and advise the practice and advise the doctors whether or not, A, it makes financial sense, and B, it makes sense from a legal healthcare fraud regulatory perspective. Because if you go in without getting the right advice, and it doesn't work out, it can cost you millions. You could be under government investigation. You could have your license suspended or revoked. You could go to jail in the most extreme cases. And the thing is, a lot of doctors say, well, that'll never happen to me. I know these guys. They're really good people. Or they told me they've already talked to a lawyer and their lawyer says it's fine. I tell the doctors, there's a lot of bad actors in this business now. A lot of shady characters that are pretending to be legitimate investors, savvy, experienced, knowledgeable in healthcare, and are trying to convince you that this is a really good opportunity for you, and that if you don't take it now, you're going to miss out. I said, the reality is they don't know any more than the other guy down the street about healthcare, much less these laws and what it means. And when they tell you they've talked to a lawyer, 9 times out of 10, they're blowing smoke. There is no other lawyer. They've talked to no one. Okay. They're just trying to convince you that they did to get you to sign. Remember what I said. You're the most important person in this ecosystem, and they can't make money without you. So if they can convince you that this is a good deal and get you to sign up, they can start printing money. Okay. That's the way they view it. Now, they're not going to tell you that, but that's exactly what's going on behind closed doors. And unfortunately, for some doctors who, for one reason or another, didn't do their due diligence, they didn't hire the right lawyer, because that's important too. I mean, I've dealt with clients that first they went to a real estate lawyer who has zero knowledge and zero experience in healthcare. They asked them for advice. No, that'd be like, if you're trying to figure out whether or not you need a stent, you don't go to a dentist and ask them that. I mean, you go to the specialty that does that specialty. I've had clients who want to go on the cheap, right? They just, hey, the guy said it. He talked to a lawyer already. I don't need to spend money on a lawyer. We're good. I get it. Nobody likes to spend money, but you got to think like anything else. If you have a business and your license is a business, if you think about it, that is the most important thing that you have, that you hold, is your license. It allows you to earn a living as a practicing physician in any setting. So you have to protect it at all costs. Yes, I get it. Maybe you don't want to spend some money here and there, but that is an investment. Just like hiring an accountant to do your taxes. And let me tell you something. Most doctors do it right, okay? But I cannot tell you how many doctors I have found in bankruptcy that did not pay their payroll taxes, that have been burned for not doing their payroll taxes. They thought that Mrs. McGillicuddy in the back office was doing the payroll. Nobody was doing the payroll. IRS came knocking on the door. You owe us $100 million penalties and interest compounding daily. And they're dumbfounded. Well, how could this have happened? You didn't have a CPA. I mean, it's that simple. You should have hired the right people to handle your payroll taxes. And then you would not find yourself in this situation in bankruptcy court with the IRS breathing down your neck with potential criminal liability for not paying the payroll taxes. Same thing here. If you don't hire a healthcare lawyer who's experienced and has the knowledge and the wherewithal, you're taking a chance. Or you don't hire any lawyer, you're taking a big leap of faith. And in this day and age, that can be a huge mistake for doctors to do, or for medical practices to do.
And Jose, just to kind of hone in on that, I mean, is there any specific advice for physicians or physician groups, and they're always being approached by private equities, like, is there any kind of red flags or any kind of screening that you would recommend for them to, before they kind of go into these contracts?
Well, first of all, if anything that's said to you, get it in writing. That's a red flag if they're not willing to give you anything in writing, right? Handshake deals they're not real deals. Okay. So if they want to propose something like a joint venture, or they want to bring you on board as a medical director, or they want to bring you on board as an investor, you need to see the contracts. You need to see the agreements, the operating agreement, the medical director agreement, whatever it is that this arrangement that you're going to have with them, you want it in writing. Okay. And you want to have and then I would say, yes, the medical part of it, but the legal part of it, you got to have an attorney review it. Because I look at it with my experience as a former prosecutor, I know exactly what DOJ will be looking for when they look at these. And I'm also going to give you a caveat. All right. So let's just say the agreement looks fine, that you reviewed it with a lawyer and everything on paper looks perfectly good. And I could advise you, look, it sounds good, but we also need to look at who the other people are, right? We need to investigate who they are. Are they an established private equity firm from Wall Street who already has experience in healthcare because they have other health systems and they haven't had any prosecutions or any investigations or any negativity? Or is it somebody nobody knows? Nobody knows who this guy is. Some guy from Alabama who was selling cars 3 months ago. He updates his LinkedIn profile and he gets a suit and a briefcase and he puts up a nice flashy web page. And now all of a sudden it looks real legitimate. Like he's just like Blackstone or some of these private equity firms that are out there. But it could be all a facade. It could be all, fake. I had a client once. He was not a doctor, but he was somebody who wanted to invest, and he saw a flashy web page where he could own and operate his own medical practice in his state. He could hire doctors who could do televisits from his clinic, and he could offer and sell and inject knockoffs of Wegovy or Ozempic to his patients. And so the ad online said he could do this. And he had a friend who was a partner in our firm who said, "Hey, you really need to talk to a healthcare lawyer, because they need to vet this out for you to see if this is legit or not." And so he came to me. I looked over everything and I basically advised him not to do it because there were a lot of red flags. And the other side said the same thing. Well, I've got a lawyer who's looked at it and he says it's perfectly fine. I said, well, ask him for the contract. They sent it. I looked it over. There are a lot of red flags in the contract. Well, the biggest one was he got the knockoffs, they assume no liability. It's 100% on him. Okay. So if anything happens to a patient, they get injured, they die, it's 100% on him. He will cover their liability if they get sued. That
Right.
was a huge, huge red flag. I then also informed them that where these guys were, they didn't have a corporate practice of medicine prohibition. So they could hire doctors. Where the investor lived, you cannot. So say you cannot own and operate a medical clinic. You cannot hire doctors. You cannot direct them or supervise. I said, also, you don't know anything about healthcare and you're going to be injecting people with this substance that you know nothing about. He said, well, they told me a doctor in Florida had invented it. I said, what doctor? He said, he's on the website. I go to the website. I see a man in a white lab coat with a stethoscope. There is no name either on the picture, below it, or anywhere in the website identifying who this man is. I tell him, that could just be some stock photo they put on the web page, and it's not a doctor. I said, who makes this substance? Well, they told me they had a reputable compounding pharmacy. What's their name? Well, I don't know. I said, okay, so you don't know the source of the compound. You don't know what's in the compound. You don't know who came up with the compound. You're going to be owning and operating a medical clinic. You're going to be injecting patients yourself personally. I told them, and they only want $100,000 from you, and they promise you that you'll make millions. I said, look, I get it. You're excited. You think they've talked you up. This is a great opportunity. I said, but the attorney general of the state is probably going to come after you for doing, corporate practice of medicine because you're not licensed to practice medicine. Somebody gets hurt or injured, you're going to be sued, okay, for gross negligence. And the state AG may come after you criminally also for what you've done. I said, it's going to cost you millions. You're probably going to lose everything you own and you might end up in jail. I said, so it's up to you entirely if you want to still jump off the ledge, but I'm telling you that I would not do it. So he listened. He didn't do it. He wasn't happy. I said, well, would you have been more happy if all of those things happened to you? So, sometimes no is not a 4-letter word. Sometimes no can save you and save you from yourself. And that's not to say there aren't good opportunities. There are good opportunities out there. But you, as a practitioner, have to decide how much control do you want to give up? Okay. How much of the profit margin do you want to keep? And what's the right work investment, personal life balance you want for yourself?
Right.
Okay. And those are questions you have to answer. The problem is doctors are busy. Doctors are either in the hospital or with patients, and they're just keeping up with the paperwork because that's big requirement. And now with electronic health records and all that stuff, it occupies a lot of oxygen in the room. I get it. We all get it. But if you're going to seriously consider an offer or an opportunity, you got to do your homework. Okay. No different if somebody says, I've got beautiful lakefront land that I want to sell you. Are you just gonna, he showed me a picture of it. It's beautiful. Here you go. Here's $500,000 for that beautiful lakefront land. No, you're
Yeah.
not. You're not gonna drop $500,000 without going and looking at it yourself because you don't know if this guy's telling you the truth or blowing smoke. This is no different. Okay. They tell you this is a great opportunity to make millions for yourself, for your family. It could be, but then again, I'm telling you, probably 6 or 7 out of 10, it ain't what they're saying. Okay. It ain't. And you can see some of the cases that have come out around the country where doctors, they're either themselves being prosecuted or they're at least under investigation. And here's the other thing I want doctors to take away from this. Their doctor would say, well, look, that's not me. I didn't know that they were going to do this. Okay. They did that. That was on them, not on me. Yeah, but the feds, they don't know that. Okay. The state doesn't know that. They're going to look at you upside down and right side left. Okay. They might issue a search warrant and come visit you at 3 o'clock in the morning in your private home and pull you out, or at the hospital. They might pull you out at the hospital in front of your patients, in front of your colleagues. This is real. This happens. They might seize your computer at home, seize your computer at work, image it. They're going to interview people that are your colleagues. They're going to interview people that are your patients. In other words, it's not so simple that they're the bad guys. I'm the good guy. I did nothing wrong. The government's going to do their investigation. Okay. And you don't have any say in that. They hold the cards. So that means that everybody around you is going to know you're under investigation. The hospital will know, your colleagues will know, maybe your patients will know, and there's nothing you can do about it. It's going to be legitimate because you have an arrangement with these bad actors. All right. And if you happen to get paid or get something of value from them, if that arrangement is not covered by an exception, then you could be also in trouble for violating the anti-kickback statute. So these are very real world concerns that I think doctors have to have. And as we progress with artificial intelligence, right, along with private equity, this creates additional risk for providers. On the one end, if you're utilizing artificial intelligence, you could still be facing in the future allegations of fraud because they're going to look at what you used as a tool. Was it properly, what's the source of the AI? Was it properly maintained? What's the source of the information? Who supervised it? Who made sure that the output was accurate 100%, right? So in other words, it's not easy to say it's AI's fault. It's not my fault. No, 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 no. You bought it or you leased it, you used it as part of your practice, just like you have a nurse or a medical assistant or physician assistant, you are supervising, okay? You supervise AI too, whether you like it or not. So you're gonna have to have a tech person involved, at least one, two, and you gotta be savvy and understand all the changes in the law and the technology and keep up with it. So there's a lot of risk involved with that, okay, with AI. The flip side of that too is risky. When Medicare now and commercial payers are using AI to screen claims, to determine what claims to approve and deny, that's going to create new litigation. They say it's going to be better. I'm not convinced because I feel like there's still a lot of hiccups that have to be worked out in the system and it's ever evolving and changing. And so it could end up being a lot of false negatives where they're denying claims that should not have been denied. And then they claim they're going to have humans review the results of those denials. I don't know. Maybe yes, maybe no. But what's going to happen is a provider, you're going to have to challenge it. And if you're going to challenge it, just like the old days with the statistical sampling, you're going to have your own tech experts review their AI, or at least you're going to have to be able to prove with your documentation that, for example, this patient, there was medical necessity for the services that were provided, or the services were in fact provided if the claim is it was never provided, or if the claim is it was not medically indicated. Before the claim was they have a dentist reviewing my claims. I'm a gastroenterologist, and they've got some dentist telling me that that service was not medically indicated, or a nurse, or someone that's not a gastroenterologist like me. I think it's a fair critique. But now if you throw AI into it, AI didn't go to medical school. AI didn't went to residency program or completed a fellowship. They don't have that experience in the hospital, that human interaction where they can read a person. Remember, I've always grown up knowing that what we have here is the healing arts, right? The healing arts. That's what medicine is supposed to be. Okay. It's part science, it's part art. And that comes with experience. That comes with you interacting with patients over time, developing the sixth sense, if you will. Can AI duplicate that? That is an open question, right? And then there's another thing too. There's the human element of physician-patient relationship that I don't think AI can duplicate, all right? because that human connection also contributes to treatment, to recovery, and to good outcomes. Can AI duplicate those good outcomes if they don't have that human connection with the patients? These are questions that remain open and will remain open for the foreseeable future. I think if I was a physician, again, I'd be concerned of private equity getting boxed out and marginalized and ended up, getting whatever is left over, or worse, getting dragged into an investigation or a prosecution. And with AI, I'd be concerned about, you know, am I going to get replaced by a chat bot who's going to basically be doing the diagnosis or the procedures, and they don't need me anymore. So it's an interesting time, really, to be in medicine. Many say now that it's not the practice of medicine anymore; it's the business of medicine, and that's a sad commentary, because I think most doctors, when they went to medical school, when they became doctors, I think the intent was there's a genuine love for providing care to patients. It's a
Right.
vocation, not a business. But unfortunately, a lot of things that are out there and people out there who are trying to influence physicians and get them all worked up and redirecting their attention from patient centric to profit centric. And I think when you go profit centric, you run the risk of bad outcomes with the patients. And when that happens, it's just going to compound and make it financially worse over time, not better, worse.
Right. I mean, those are fascinating points, and you've touched on, quite a myriad of things and what the future looks like with technology and how that's kind of, you know, weaving its way into, healthcare operations at all levels, but particularly also of a patient care level. So that's fascinating. I mean, just the other issue that's sort of, been percolating for a while, and I know you've commented on this, is sort of the consolidation that's happening across healthcare services. And what's your take of legislation and how the DOJ or the FTC is kind of viewing these consolidation and the antitrust implications of this? These sort of massive mammoths are kind of really determining and shaping the course of how things are going to go in the healthcare market.
Yeah. So DOJ is clearly, and the FTC is clearly looking at these consolidations, acquisitions, growth, if you will, where they're serial acquisitions, and many times private equity is involved in those too, and how that impacts competition. How does that impact access to care for patients? And how does that impact doctors who are outside who want to be given the opportunity to go and get credentialed at the local hospital? Unfortunately, what happens and we've seen happen is some of these practices become so large, and it doesn't have to be national. I mean, it could be within a certain metropolitan area. I think there's a case pending in New York City involving one of the hospital systems, where they've basically, in some respects, trying to corner the market, and they're boxing out certain practice groups from getting credentialed and getting privileges at the hospital. So they're giving sort of favored nation treatment to some practice groups where they have a very good financial or otherwise arrangement with. And DOJ is looking at that very carefully because it's anti-competitive. And so, like in Texas, where you have an anesthesiology practice growing and acquiring smaller anesthesiology practice to the point where they're the biggest player in the state of Texas, or potentially could become the biggest player. And they start doing, making arrangements with hospital systems and boxing out other anesthesiologists. So if you're an anesthesiologist and you want to open up your shingle, and for you, unless you're pain management, you're going to be in the hospital. You need to be credentialed. You need privileges. Well, if the big boy on the block says it's just us, then the hospital boxes out the other anesthesiologists, and they can't make a living. They can't see their own patients, if you will. And that works for cardiologists, any specialty really. And so, yes, DOJ is very much interested in that, and very much FTC is interested in that. And they brought that case against the private equity firm that was involved with the anesthesiology group in Texas. They got a consent order with them. And what it did is, and it's not financial, it's about just trying to control their involvement in the marketplace or divesting themselves of certain interests. But what it more importantly did is it sets precedent. So now when the government sees private equity gobbling up practices, and creating this monolith organization that's going to box out smaller practices. They now have precedent and they can go to private and say, hey, you need to divest yourself of these, or you need to stop from any further progress, or we're going to come after you as well. So it's not just the actual practice itself and the doctors, it's what's behind them now that they're looking at. And so, yeah, this is big, and it's been going on now again. And again, I tie it to private equity. I really do, because it's like, how do you maximize your return on investment? Gobble up competition, create your your super practice across the state, across the country, and start knocking out all your competition. And then you control the price, what you charge, you control who gets credentialed and privileges at certain hospitals. And that becomes a problem, because it really does affect access to care. It affects doctors' ability to practice medicine, and it affects overutilization and the cost of utilization.
Right. And do you see that this trend that we're kind of been observing, this sort of continued increased consolidation, continued private equity investments, is that trend likely to continue the same way, or do you feel that that we may see some changes?
Well, for now, it's going to continue until we start getting more, serious prosecutions or judgments entered against private equity, and that are going to have to get appealed, go through the court of appeal process, and be finalized. Because again, at the end of the day, if it costs more to do something than not to do it, then that's what's going to stop companies from doing it. But as long as they're making more money than it costs them to do it, they're going to keep doing it. I mean, it's just logical. It's sort of like, well, this is the cost of doing business. Okay, so here's how much we bring in. This is how much we have to pay our lawyers and go to court and defend ourselves. And if we're, they're like, okay, it's still profitable to do it. They're going to keep doing it. So what I do anticipate happening is more legislation. I can see new laws coming down the pipe in the next 3 to 5 years that's targeting private equity, both at the state level and at the federal level. That's maybe going to regulate private equity's involvement, in which case, then yeah, that's going to curtail private equity. But, you have to be very careful when you do this, because you can't necessarily say arbitrarily, well, nobody can invest in healthcare. So they have to find the right balance. And I think what they're going to find is private equity can continue to do it, but they're going to have to meet certain requirements to do it so that it doesn't get out of control. But right now, it's like the wild, wild west. And it's not just the major firms. Like I said, there's those small little one guy, two guy. We used to sell cars a few months ago. We're jumping in. There are social media influencers that are entering into the space. All right, and overnight they're bringing in money. I think of. Have you heard of Hims and Hers?
Yes.
Yeah. So Hims and Hers. So a few years ago, when Ozempic and Wegovy took off as weight reduction drugs, even though that wasn't necessarily what they were initially approved by FDA, although later they got approved for obesity, treating obesity, became the craze. And then suddenly there was a shortage of them nationally. So FDA announced there was a national shortage. And when they announced that, it allowed licensed certified compounding pharmacies to basically manufacture what would otherwise be considered a generic version of Wegovy and Ozempic
Right.
to the public.
Yeah.
Okay. So that was it was authorized by FDA for them to do it. Well, then you had Hims and Hers jumping in, and others, not just them. I don't want to just single them out, but there were others who jumped into that market, if you will. And now everybody and their mother was offering versions of Ozempic and Wegovy. But the problem was that you wouldn't know if they were using a legitimate, licensed, certified compounding pharmacy to create it. Maybe they were, maybe they weren't. Well, fast forward it. So now there's no shortage anymore. So the FDA announces the shortage is over, because the manufacturers, I don't remember if it's Pfizer or Eli Lilly, but the manufacturers, they now had enough supply to handle the demand. When that happens, the pharmacies, the manufacturers have to stop producing what otherwise would be considered a generic version of the drug, where they're using the active components of the drug. And basically, they may use different inactive drug components, but it's still would otherwise be considered a generic version of the drug. And here's the thing, there is no approved generic for either one of them. To this day, there's still no approved generic. If they're made either by the manufacturer, which is FDA approved, or by a compounding pharmacy. But here's the trick. Compounding a drug off of an FDA approved drug has to be for a very specific purpose for a specific patient. And you have to document it, and it has to be, well supported in the medical documentation. That's sort of like a one-off. It's the exception. But what you're going to see is certain companies are continuing to do business as usual. They're still making, I'm call them a knockoff because they're not FDA approved, versions of Ozempic and Wegovy, and they're not FDA approved. Now, they might argue, well, each one is individualized to the patient. The devil's in the details. I suspect in some cases, what you're going to find is it's the same formula being manufactured 100 times over, okay? And they're just writing the scripts like they were before, nothing different. They're doing telemedicine because it's cheaper, and they're with the patient for 5 minutes if they're with the patients at all, and they're getting this knockoff version for a few $100s less. These companies are going to argue it's individualized, but I think when the feds look at it carefully, that's not going to be the case. It's just a mill. They're running the same formula for all the patients, regardless of what their background is, regardless of what their symptoms are. It's the same rubber stamp for each one of them. That is not allowed. Okay. They're basically manufacturing a generic version without FDA approval, is what they're doing. So at some point in time, that hammer is going to come down. So, I mean, and I think that's true of any drug or that's out there. So, we talked about this previously, the off-label use and how does that work for a physician? So off-label is you have an FDA-approved drug. A doctor has determined either through their own research or published, peer-reviewed, double peer-reviewed, if you will, double-blind testing, that that drug has shown that it can be appropriate for a different condition that was not submitted to FDA for approval. The doctor may make a decision using their medical judgment to prescribe that drug for their patient who is presented with a specific set of symptoms with a specific condition that does not respond to what would be typically given to them. And so you're looking for an alternative that might be helpful for that patient. As a practitioner, as a licensed doctor in the practice of medicine, that's okay. And it happens everywhere. It's perfectly normal. There's nothing wrong with that. Where it becomes a problem is if the pharmaceutical company comes to the doctor and says, look, this is a great drug for A, but you can also use it for B, C, D, and E, and here's some literature to help you with doing it. Look, the doctor's free to accept it or decline it. Yeah, okay, thanks, appreciate it. But the government's going to look at that and going to say, okay, did the pharmaceutical company offer or pay the doctor to experiment, to do some research with the drug with their patients? Well, the government's going to want to look at see what that research really looks like, okay? Because there's no way that research is going to replace clinical trials and the rigorous process that is required to get FDA approval. This is like anecdotally. But the government's going to want to see, okay, what exactly did you do? How did you document it? And then they're going to go to the pharmaceutical company who's doing this with a bunch of doctors across the country. Let me see your quote unquote research. And if it, and look, I'm going to tell you, based on my own experience with the government, most of the time, there ain't no real research going on. They're just paying the doctors to prescribe the medications. That's the honest to God truth is what's really happening. Okay, people can just talk themselves into anything, but no, because once you go and say, show me the details, there's nothing to find. Because when you look at the chart, it looks like that guy's chart. It looks like that guy's chart. There's nothing significant or unique or different about the chart that would lead you to believe that you've just did some real research on the drug's effects and use for that patient. You're going to get in trouble. It's high risk to accept anything of value from a pharmaceutical company in return for doing research. And 9 times out of 10, there's nothing in writing. I've had doctors tell me, oh, well, they told me this and told me that. And I said, do you have something in writing? No. Well, I would strongly recommend you talk to somebody about this situation because I would stop, if I were you, immediately from accepting any more compensation for doing this research. So if there's no compensation, and they're just bringing it to you, and you read it, and you decide on your own, yeah, this might work for a patient, fine. But it's when the pharmaceuticals, there's money involved, or they're doing marketing. You can't market without FDA approval. So you can't put a flyer in front of your clinic now offering this for this. That's considered marketing of a drug. And if there's no FDA approval for that, you cannot do that. That would be illegal. Okay. The only way this really works is you got the patient in the room, you've reviewed their medical history, you've reviewed their testing, you know their background, you know their condition, you've tried what is already on the market available, and you've determined based on your own personal review of literature that this drug would be good for them, or at least worth a try. Okay. And then the follow up is, okay, you tried it. Did it work? If it didn't work, you got to stop. See, because that's the other thing that happens. Once the pharmaceutical gets the doctor to prescribe it, they want them to keep prescribing it. Well, the research isn't indefinite. It's not forever, right? It's not like I'm getting 10,000 a month for the next 5 years. No, no one's going to buy that. Oh, you did research for 5 full years using this drug. So it's not going to happen. I mean, we have to have a dose of realism here. Be realistic about what's going on. And again, as physicians are bright people, they have to be in order to go through the process of becoming a doctor. But unfortunately, for one reason or the other, when they get approached, for some odd reason, they put on a different hat, and these guys are somehow able to convince them that this is a good thing to do, and they do it. And the next thing you know, what happened? Why am I being investigated? I did nothing wrong. Well, it's because you didn't see it, or unfortunately, in some cases, you didn't want to see it, right? And that's what gets you in trouble. My job now is to educate physicians and practices. My job is to inform them and to advise them based on my experience being in the government, having dealt with it from the other side, doing the investigations, working with law enforcement, going after providers, and be able to say, look, I'm telling you professionally and based on my experience, either A, this is good, either B, this is bad, or this is somewhere in between, and you're going to have to make a decision because this is not without risk. Okay. And I'm not talking about financial risk. I got guys for that. I'm talking about from a regulatory perspective, from a kickback perspective, there may be risk involved, which means that you might be okay in the end, but that's not going to prevent you from being under an investigation. And before I forget, the other thing I hear from doctors is, well, those guys went to jail. Those guys are the bad guys. I did nothing wrong. They did not prosecute me. They did not do this. They did not do that. So I'm good. Not so fast. This is the other thing doctors need to be aware of. So there's an investigation. That other company gets in trouble. They get prosecuted. Some of them plead guilty. Some of them get found guilty by jury. And you're thinking the case is over. No, 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 no. Honestly, the case may never really be over because you could be an unindicted co-conspirator, or you can just be an or unidentified person who was involved. So they don't name you in the complaint, but you're still under investigation. And you can remain under investigation for the next 3, 5, 6 years, and you will never know it. And you're thinking, I'm in the clear, but you may not be. And here's the other thing. Doctors will say, well, can't you get them to say whether or not, I'm in the clear or I'm good to go? No, because DOJ policy does not. They won't give you what we call in the industry a cold comfort letter, which basically says, look, you're off the hook. And the reason they won't do that is because they don't know what they don't know. So tomorrow they might find out that you were doing something they didn't know today. So they're not going to give you that cold comfort letter, because then you're going to try and say, I got a letter that says I'm good to go. And they're going to say, yeah, well, and they're going to have to fight over it. So instead of fighting over it, they're just not going to give it to you. So that means it stays open. And if they get more information or evidence that you were more involved, then they're going to come after you. And so best thing is do your homework, hire the right people to advise you up front, and try to mitigate or avoid having to deal with this. But if you don't, or even if you did and you run into trouble, you also call people like me, because not only do I work with people up front, I definitely work with you if you're under an audit or under investigation, you've been issued an OIG subpoena or a grand jury subpoena, or they filed a whistleblower case against you, or we have a criminal case against you. We work to represent you and to help you respond to it. And look, with me, I'm not gonna BS you. Okay, and that's what you want. You want someone to give you tell me the truth. Tell me, what am I facing? What's going on? And I'm going to tell you, I'm going to say, look, here's the situation. And I'm going to advise you and tell you what your options are. And ultimately, you as a client are going to make the decision, but you're going to know what your options are and what the risks of each option are going to be. In some cases, the best option may be to come to some agreement with the government to save your license. Because especially in criminal, if you go to trial on a criminal case where they have charged you with a felony offense of healthcare fraud and you are convicted, bad things are going to happen. Number one, you're going to be automatically excluded from all federally funded and probably state funded healthcare programs just off the bat, 5-10 year minimum. All right. You're going to be reported to your licensing authority, which means you're probably going to get your license suspended or revoked, one or the other. And it's going to be reported to the National Practitioner Database. So that's going to affect credentialing. It's going to affect privileges. It's going to affect with insurance carriers and hospitals and ASCs. I mean, so in other words, there's a ripple effect. It's like a domino effect. So don't just think of it in terms of like what's right here. It's what's coming behind it that's going to impact you.
Right. That's great points, Jose. Jose, the other thing we just wanted to quickly touch upon was another thing that we notice in the healthcare market these days is these medical spas. They're kind of booming. You're seeing these lasers, injectables, aesthetic procedures being marketed everywhere. And a lot of the times when you look behind it, they're run by non-physicians or corporate ownership. Speak to that, if you may, in terms of the legal liabilities and the landscape and the issues there.
Yeah. So the gentleman that I mentioned earlier, that investor who wanted to get in on on selling the knockoffs of Ozempic. When I started advising him on the red flags, he brought to my attention, well, there's medical spas in another state and they're able to do this. And I said, all right, well, and he wanted me to look at it. So I did. And what I found out is you have to look at the laws. And the laws are very clear what the practice of medicine is versus what is not the practice of medicine. Excuse me. And what we find is in that case is, look, what he wanted to do was the practice of medicine. It's being used either to diagnose, treat, or cure an illness. Obesity is categorized today as an illness, and it has been for some time. That means that a medical spa, if they're going to be prescribing, if they're going to be injecting Ozempic or some other similar drug, it needs to be done by someone who's appropriately trained, independent of the state, certified, and under the supervision of a physician. Supervision is one of those words where people say, what does that mean? Do I need to be in the building? Can I be on the other side of the world? No, you cannot be on the other side of the world. All right. So supervision means you got to be a stone's throw away. I mean, in case something bad happens, you have to be immediately available to, especially in the OR, which is clearly where you most definitely want to have somebody who is immediately available to assist. But in a med spa, first thing is, okay, is it a medical practice or is it truly, are you treating obesity or are you just doing a facial? He's going to do a facial, put a little something. It depends on what the purpose is, right? Some say, so the devil's in the details. It depends on the states. These are regulated by state in many cases. States might require a physician to be a medical director. They might require, as a medical director, they be on site. They might require them to be supervising or have another healthcare professional, like a nurse practitioner, supervise or be the ones who are actually performing the services that are considered medical services. But again, you got these social media influencers who see an opportunity, and the craze is med spa. Even the name itself is an oxymoron. I mean, a med spa. So the name implies you're coming there and you're going to get some type of medical services at a much more reduced rate, a reasonable rate. And you don't know who you're getting. Could be somebody who just graduated high school, doesn't know anything, and there's nobody there trained to supervise. What happens if there's a bad outcome? Who's going to be responsible? Well, the owner's going to be responsible. The person who did it is going to be responsible. And if there's a medical director, they could be responsible. Like that case with the med spa I think it was here in Texas, if I remember correctly. The doctor was nowhere near. Somebody was injecting somebody with some substance. The person died. That owner who was doing the service as well was being prosecuted criminally. The doctor was being prosecuted criminally. There were civil lawsuits filed against both. I think the doctor lost his license for some years. So that's the craze. But again, if you're a physician, and you're being offered an opportunity to be a medical director, like, no different than the home health agency. You need to go in with your eyes wide open. You need to make sure you understand what the state law is for medical spas and what your legal obligations are as a physician. You might decide, I don't want that responsibility. I'm not interested. And you walk away. Or you say, you know what? I'm interested, and you accept the responsibility and you take it on. And that's fine, but it has to be documented. You have to make sure you have logs of what you did, when you did it, to support it. Because if all you have is a paycheck or a wire transfer once a month for being a medical director, but there's no evidence that you were in the building, there's no evidence that you actually did anything, there's no evidence that you actually supervised anyone, and something bad happens like that Texas case, you could be on the hook too.
That's very sobering thought. So let's thank you so much. I mean, we covered a lot of different aspects. As we round up, Jose, any kind of viewpoints on where the future of healthcare regulation is going, and are you looking for anything closely? And what do you think will define the next 5 years in the healthcare market?
Well, I think we've touched upon them. I think artificial intelligence is obviously the latest and greatest craze. And I don't think you were going to see artificial intelligence leave medicine. I think it's going to be a part of the practice of medicine. And I think that that's something that we need to pay close attention to, both as a tool that we use for diagnosing, for treatment, or trying to cure a disease. So it can become an integral part of the medical practice, but it does require close supervision. It does require maintaining updated information. I mean, right now, I wouldn't say AI is 100% foolproof, right? So it's a tool, but it needs to be calibrated. It needs to be maintained. It needs to be, keep current. So we'll see how that all plays out. And flip side of it is when your claims are being processed through an AI system and they're being denied, and then how providers are able to respond to that in a way that's effective, so that false negatives are being properly adjudicated through an appeal process. So I think that's big. And then again, right now with private equity and these acquisitions of different practices and how that affects competition, access to care, and corporate practice of medicine, and also fraud too, because if these investors are compensating providers in one form or another in return for referrals, that's going to be an issue too. And there's been several cases, and I don't see those going away anytime soon. And look, the feds are getting very aggressive in the last couple of years. I also anticipate that the states are going to start to get aggressive. Some states are more aggressive than others historically, but I suspect with money being tight as it is, I could see states starting to ramp up their own prosecutions and enforcement actions. So now you're going to be faced with dealing with both the state and the feds. And here's one other thing that people don't really know. But when you talk about the anti-kickback statute, everyone focus on Medicare, and Medicaid is partially federally funded. But what they don't know is that at the state level, almost every state, if not all of them, have a state anti-kickback statute or something equivalent to it. In approximately half of the states, it's only tied to state-run benefit programs. But on the other half of the states, it also covers private pay. And what that means is, unlike the federal anti-kickback statute that only applies to Medicare and Medicaid or TRICARE, for example, or maybe OPM, Office of Personnel Management, which is a federal employee health benefits program, which is also federally funded and will be covered here. At the state level, if we're talking about expanding it beyond Medicaid, that means if you commit fraud against Blue Cross Blue Shield, the state AG can bring an action against you if it's based on kickbacks that are being paid between a provider and, let's say, a lab service, where they're just ordering up lab work and there's no medical necessity for the lab work. Or they're ordering it up and they're not actually doing it, but they're billing Blue Cross for it. Now, what Blue Cross and Aetna and some of these commercial payers have done is they've brought their own private causes of action for fraud based off of their contractual agreement with providers. They're bringing these lawsuits against them for millions of dollars. Very similar to DOJ bringing cases against providers for committing fraud against Medicare, but these are private insurers who are bringing their own cases for fraud against their carriers. Well, add a layer of AG now that they too might jump into the fray more. So I can see that happening in the next 3 to 5 years as well. as they try to tighten the budget, with the Fed saying we're going to pay less for Medicaid, states, you're on your own, or you're on your own for the most part, then the states are going to have to find ways to protect their money. And I can see them ramping up prosecutions and enforcement actions to protect their Medicaid money, to protect private pay money that's in the state where the AG is located.
Interesting, interesting, and very sobering. Well, thank you so much, Jose. I mean, it was truly wonderful, a pleasure to talk to you about a whole myriad of issues, and particularly, your illustrious career. I mean, you worn the uniform for the country. You sat on both sides of a very consequential table, dealing with healthcare law, and you've used everything that you've learned to protect people who dedicate their lives to caring for others. And I think that is a form of service that doesn't quite get enough recognition. So we truly appreciate you for that. And we're grateful for your time, your candor, and your commitment. Thank you, Mr. Jose Vela.
And thank you all. I appreciate the opportunity to visit with your audience and have this conversation. I think it's an important conversation. And I think many times it's important to hear it multiple times. So repetition, 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 and you develop muscle memory. And so hopefully some of this sticks. And the next time one of your members of your audience is faced with a dilemma or making a choice or an opportunity, or they're already involved in something that they learned they wish not to be involved with anymore, the right thing to do is retain the right counsel to provide you assistance and advice so that you make good decisions based off of good advice and try to minimize the cost to yourself. Because like I said, yeah, your audience has worked very hard to achieve the success that they've achieved, going through college, going through pre-med programs, completing a medical school, getting through residency, fellowships, becoming board certified. I mean, it's a long road. And it's a lot of sacrifice to achieve, to be licensed and have the opportunity to provide care to the community and to get that fulfillment of providing that service, that utility to the community, and obviously to be compensated for your work and your sacrifice. It's all appropriate. And again, your license is important and you want to protect it. And so when you think about what we're talking about and taking steps to what we're talking about is taking steps to protect your license and your ability to continue to practice medicine. And I think that's really the takeaway is that just like filling out your taxes and making sure you pay your taxes, you want to also make sure that you protect your license by making good decisions as to how you're going to use that license.
Awesome. Thank you. On that note, thank you so much. Okay.
Thank you for joining us on Beyond the Scalpel. We hope today's conversation gave you new insights into the future of health, healing, and human performance. If you enjoyed this episode, be sure to subscribe and share it with others passionate about medicine, wellness, and innovation. To learn more about Dr. Mamun Alrashid, visit www.palmbeachregenerativeorthopedics.com. Until next time, stay curious, stay informed, and take care of your health, both inside and beyond the scalpel.